Hello and welcome to this ABILA pre-ILW webinar, The Right to Equal Participation in the Judiciary and the International Court of Justice. Where are the women? My name is Dr. Jessica Corsi, and I'm a senior law lecturer at the City Law School at City St. George's University of London. I'm also the co-founder and co-chair of the Working Group on Gender Parity for the ICJ. The working group is a diverse international network of practitioners and academics working to address the historical and ongoing overrepresentation of one gender on the World Court. I will be co-moderating this panel with my colleague, Professor Melina Stereo, the James A. Thomas Distinguished Professor of Law at Cleveland State University's Cleveland Marshall College of Law and a steering committee member of the working group. The Working Group on Gender Parity for the ICJ is delighted to co-sponsor this webinar not only with ABILA, but with additional partners, including GEQUAL, the Institute for African Women in Law, and WILIG, the Women in International Law Interest Group of the American Society of International Law. This webinar also serves as the official launch of a new ABILA committee that Professor Melina Stereo and I will co-chair, the Gender Justice in International Law Committee. This committee focuses on advancing gender justice within international law through analysis, advocacy, and targeted policy recommendations. The committee will monitor gaps in international law and have international norms and practice, and develop guidance on gender-responsive implementation and foster collaboration among civil society, academia, legal practitioners, and international institutions within the auspices of ABILA, the American branch of the International Law Association. ABILA does not currently have any standing committees on gender justice, and so we are proud to launch one today. And today's gender justice topic, of course, is the right to equal participation in decision-making, including within the international judiciary, including at the International Court of Justice. This right, the equal right to participation in decision-making, is a fundamental human right, enshrined in international law, in many locations, many sources, including the International Covenant on Civil and Political Rights, the International Covenant on Economic, Social, and Cultural Rights, and the Convention on the Elimination of All Forms of Discrimination Against Women. In its General Recommendation 40, issued 1 year ago in October 2024, the Committee on the Elimination of Discrimination Against Women, the CEDAW Committee, made it clear that this fundamental human right applies to international judiciaries. General Recommendation 40 also notes that despite the fundamental nature of this right, states do not enforce it. The International Court of Justice is one such example. In the almost 80 years of the court, only 5.22% of its permanent judges have been women, the rest men, and no data is known regarding other genders. The next election for permanent judges will take place in November 2026. And currently, out of 11 nominated candidates, only 3 are women, and the remaining 8 are men. Our collaborator GEQUAL has calculated that if this rate of change continues, the International Court of Justice will not have a gender equal bench until 2056. We believe that justice systems should reflect the diversity of the societies that they serve, and that the International Court of Justice is no exception. Known as the World Court, the historical and ongoing overrepresentation of one gender on its bench communicates the ICJ's lack of representativeness. 1 year on from General Recommendation 40, and 1 year away from the November 2026 ICJ election, we're here to talk about turning the recommendation into reality. This panel discussion will focus on the need for gender parity on the ICJ bench from a human rights perspective, with a special focus on the right to equal participation in decision-making and in the international judiciary. And to start the panel, it is my pleasure to introduce our first of 5 speakers, Corinne Detmeijer. Corinne Detmeijer is the vice chair of the CEDAW Committee to End Discrimination Against Women. Prior to this, she was the Dutch National Rapporteur on Trafficking in Human Beings and Sexual Violence Against Children from 2006 through 2017. From 1984 until 2014, she was a judge at the Court of The Hague. From 2001 until 2006, she was Secretary General of the International Association of Youth and Family Judges and Magistrates. Corrine Detmeijer holds a position in several advisory or supervisory boards and NGOs committed to human rights, and in 2018, she held a prestigious chair at Leiden University. With this, I'd like to turn it over to our first speaker, Corrine Detmeijer. Please, the floor is yours.
Thank you very much, Jessica, for this nice introduction. Thank you. And for this important webinar. And I'm honored that I was asked, and especially that I may go first, to talk a little bit about GR 40, or General Recommendation 40 of October of last year. A roadmap to parity, it is called. And we use the word parity on purpose and not equality. Equality is very often synonym for 30% is enough, but parity means 50-50. Targets of 30% for the representation of women in decision-making are incompatible with the Convention's core aim of elimination of discrimination against women. And they convey a message that inequality between women and men is justifiable. Decision-making will have real and dynamic meaning and lasting effects only when it is based on 50-50 parity and take equal account of the interests of both women and men. The equal and inclusive representation of women is also an important driver of integrity, as it disrupts pre-established collusive networks, and later we will hear more about the election process for the ICJ. As reflected in the concluding observations of the committee, a growing number of states parties have passed or are considering parity laws for elections and other decision-making roles. Parity means the full and equal sharing of power on a 50-50 basis between women and men as a permanent and core feature of all arenas, including political, public, and economic life, and of course the judiciary. Legislation guaranteeing parity is thus not intended to be removed once women's historical disadvantages have been redressed, but remains as a legal principle and permanent and universal feature of good governance. Reference to parity in the present general recommendation are always in relation to 50-50 parity between women and men in all their diversity. Patriarchal structures impede the equal and inclusive representation of women in decision-making systems. Patriarchy is a system of power deeply embedded in political, social, economic, and cultural structures. It creates a hierarchy historically assigning distinct roles, worth, and qualities to women and men, and it results in a division of labor whereby women are primarily responsible for the private sphere of the home and family, while men are the main actors in the public sphere of politics and economy and the judiciary, based on differential weights assigned to efforts in the two domains. Patriarchy permeates all societies. And in the agreed conclusions adopted at its 65th session, the Commission on the Status of Women urged that action be taken to achieve the goal of 50-50 gender balance at all levels of elected positions. Under Action 8 of the Pact for the Future, states have undertaken to ensure women's full and effective participation and equal opportunities for leadership at all levels of decision-making in political, economic, and public life. In order to achieve substantive equality in its General Recommendation number 5 from 1988 on temporary special measures, the committee urges states parties to use temporary special measures such as positive action, preferential systems, or a quota system. And while temporary special measures are sometimes misunderstood to conflict with constitutional equality or merit-based systems, in General Recommendation number 25 from 2004, the committee clarifies that the non-identical treatment of women and men is sometimes necessary to address socially and culturally constructed inequalities that hamper a true merit-based system. And the committee underlined the need to establish a strong legal framework, including targeted permanent and temporary special measures to prevent and address discrimination and ensure substantive equality in order to reach the 50-50 parity in decision making. Data on female judges worldwide learn that important steps have been made. However, judges in Supreme Court, the European Court on Human Rights, 12 women of the 46 judges, the Inter-American Court, 1 woman out of 7 judges, are still predominantly male. The ICJ judges are all scholars, so we have to look at the academic world rather than the judicial world for improvement there. The European Institute of Gender Equality states that only 26% of the professors in the EU are female, so change should start there. And I'm afraid we still have a long way to go. I became a member of the Judiciary, a learning part, in 1974, so that's over 50 years ago. And I do not want to strive for 30%, but for full parity. And when I look back on my long career, I'm sad and angry that we did not manage better for the generations to come. In 1915, when the world was at war, my great-great-aunt Aletta Jacobs organized the first Women's Peace Conference in The Hague. 1,100 women came from France, the UK, Germany, Belgium. And she said in her speech, women need to get the vote. Once we have the vote, things will change. Now, 110 years later, things did change, but not as she had envisaged, not by a long shot. So thank you for this opportunity.
Thank you so much, Corinne, for reminding us not only of the key international legal norms, but also for sharing some of your personal story, which is very inspiring. And just a quick note, I was remiss in my introduction to encourage all participants here to use the Q&A function, because after our final speaker presents on the panel, we'll then move on to audience Q&A. So please do drop your questions into the Q&A box as our speakers are presenting. And with that, I have the pleasure of introducing our second panelist, Professor Jay Jarpa Dawouni. Professor Dawouni is a full professor of political science at Howard University in Washington, D.C., and the executive director of the Institute for African Women in Law. She's a qualified barrister at law before the Ghana Superior Courts. She holds a doctorate in political science from Georgia State University. Her primary areas of research include judicial politics, women in the legal professions, gender in the law, international human rights, women's civil society organizing, and democratization. And with that, I'd like to hand it over to Jarpa. Professor Dawouni, you have the floor.
Thank you very much, Jess, and thank you, my colleagues on the panel. And of course, thank you to our participants for making the time to join us, and for those who will be watching this as a video, recorded video. I'm very grateful to be here, and I thank Jessica and Milena and all the organizers, Abila, GICO, all the participant sponsors for this very important conversation. It's never enough. We've been having these webinars, you know, the committee is doing an excellent job, but it's never enough. As Corinne ended up on her wonderful presentation, many years later, we are still trying to figure this out. So with that said, in the few minutes I have, I think I want to build up, if I can, on Corinne's excellent exposition by looking at the fact that beyond the system, from 1945, when the UN was created, when the ICJ came into force in 1946, beyond the activism that have been done by several women, including her great-great-great-aunt, beyond the fact that the international world has created all these wonderful instruments, treaties, conventions, all these recommendations, we are still here having this conversation. So that means that beyond all the laws and treaties is the human beings behind it who will decide whether, one, we create the laws, conventions, and we implement, or we create them for the sake of a window dressing and we keep moving on. And so I want to talk very briefly about the people behind these laws. For those of you who are listening, who are here, you probably do know that the election of judges to international courts and tribunals is done by human beings who are representing states, human beings who are representing the foreign ministries, human beings who represent all sectors of the different actors. Now, if the actors who are responsible for choosing the people who will end up on the courts are not gender sensitive enough, are not open enough to a diverse bench, then we will have the result that looks like the people who are selecting. So that means that in terms of the selection, we need to look at who are those. And it's not that we should all have, we should have an equal representation of men and women. It would be great. I agree with Corinne that equality must be equality, not parity. However, I also want us to bring in the men into the conversation. And I hope the next time we're having such a conversation, we'll have 2 men on there, because there are men who are allies. We women cannot continue to talk and sing together. So what are the roles of these men? Ensuring that even if women are not in the room, at the table, that we have these men who are also going to make this advocacy for us. Now, let me move away from this actor role and look at data. We hear others who are involved in this work advocating for equal representation on the ICJ bench. We're just not making it up out of sentiment. Yes, sentiment is great, but we are also making it from an empirical perspective driven by data. So I want to just make this quick analysis for all the actors who are involved, whether male or female, in the selection of judges. Look at the data. Data do not lie. What does that mean? This is not 1945. This is a time where we have come, and despite that there are still places where women are not represented, the data also show that we have a good amount of women who are represented in judiciaries at the national level and also at the international level. Very quickly, I speak from an African perspective, and I can tell you that based on research I have done, many African countries are making progress towards getting women on the bench. Africa as a continent leads the world in the number of chief justices than anywhere else in the world. The African Court of Human and People's Rights, even though it came late in 2006, has had over 50% women on the bench at one time, and 3 women have been presidents and vice presidents. So what does it say? The data show that if you seek, you will find. So those actors who are responsible for selecting women, if you look, you will find qualified women at the domestic level. At the international level, and I'm rounding up very quickly, we have also evidence to show that right there in The Hague, at the ICC, women have been highly represented on the bench, have held the presidency, vice presidency, so women can do it. Lastly, the ICJ has had a female prosecutor and many other top positions within the bench. So let me end up on this note. We need to move beyond where are the women, we can find the qualified women. As Corinne said, if it's academia, we can find. If it's within judiciaries, we can find. If it's at the regional level of courts, whether Europe, Africa, Asia, we can find. So selectors, actors involved in the selection of women or judges to the ICJ, if you look, you can find. Find the women and let's make the change happen. And let's not wait until years later, somebody says, my great Aunt Corinne made this discussion in 2025 and we're still here. Hopefully that will not be the case. I turn over. Thank you.
Thank you so much, Jarpa. And as you said, we are not lacking in qualified women who could serve as judges on the International Court of Justice. So then the spotlight turns to those that nominate and elect judges to the International Court of Justice, the Permanent Court of Arbitration national groups and their equivalents, and those who will vote for the candidates in the General Assembly and the Security Council. So all eyes on them. And someone who's been working on this issue for the ICJ and for many other international and supernatural supranational, it is October, but not that spooky yet, and regional courts is our third speaker. And with that, it is my pleasure to introduce Professor Claudia Martin. Professor Martin is professorial lecturer in residence and co-director of the Academy on Human Rights and Humanitarian Law, and the co-director of the LLM program in International Human Rights and Humanitarian Law at American University's Washington College of Law. She teaches and specializes in international law, international human rights law, and the Inter-American Human Rights System. Claudia Martin is also a founding member of GQUAL, which is a campaign to promote gender parity and international representation, and she serves as a member of the campaign secretariat. And with that, Claudia, please, you have the floor.
Thank you very much, Jess, and it's a pleasure for me and for GQUAL to be co-sponsoring and for myself to participate in this event. We have been discussing this issue for many, many years, as Jess mentioned, more than 10 years of the GQUAL campaign. So I want to take a step backwards and explain a little bit that our work with GQUAL has worked on three important pillars that pretty much have been discussed somewhat by my predecessors. First of all, developing the law. Number two, producing the data. And number three, building alliances. In terms of the law, which is the one that I'm going to cover a little bit here to complement what Corinne mentioned before, from the beginning, we made a decision, a political decision, to claim that women have a right to equal representation at the international level. And even if, as Jess mentioned, some of the international human rights instruments do acknowledge the right to equality and non-discrimination, it was only Article 8 of the CEDAW Convention that gave us the language and the opportunity to claim this as applied to international representation. For those of who are listening to this webinar, the CEDAW Convention has been widely ratified. About 189 states have ratified, if I'm not wrong. I don't know if there is any new one, please correct me if so. So it means that this obligation of Article 8 applies to almost everybody. So we worked tireless with the CEDAW committee before Corinne came. I'm very glad that she is sitting in the committee now to update a recommendation that existed before on equal representation. And eventually this turned into the adoption of GR40, which we believe is super important to promote equal representation and inclusive representation at the international level. Three important aspects that Corinne mentioned, but I want to underline from GR40 that are essential. Number one, parity as a legal principle and permanent universal feature of good governance. Number two, parity at 50-50. As Corinne mentioned, this had never been said before, as clear as in GR40. So it's a very important statement done by the CEDAW committee in GR40. And number three, intersectionality, which I think we all care about, not only some women, everybody, and women represented in all their diversity. These principles have been applied for many aspects of decision-making in GR40, but for the purpose of our discussion, I want to mention that it applies to the equal representation of women at the international level, including broadly access to international mechanisms, courts, and other organs that can be defined as justice institutions. GR40 attributes the underrepresentation of women at international justice institutions to the absence of objective criteria and processes for appointment and promotion to relevant positions, and for the lack of concrete mechanisms to reach parity. So they have specific recommendations, and I want to underline two. Number one, institutionalized parity laws and transparent procedures at the national level. Jess already mentioned that, and Jarpa as well. And then adopt parity mechanisms at the international level. How do we states vote at every instance in which they will have to decide? So we have been working at GQUAL trying to translate GR40 into action, and I have three specific recommendations in regard to the ICJ. Number one, I think that we need to apply GR40 to reinterpret the requirements to be judged at the ICJ. We have Articles 2 to 4 of the statute of the ICJ that pretty much establish how and who should be at the ICJ, we need to permit that debate applying GR40, incorporating gender consideration. It's about time. I think that nobody can claim that women should not have the right to be there. Number two, we need to request the Secretary General of the UN, when exercising its power, to request members of the Permanent Court of Arbitration and the national groups, in each state party to nominate candidates, to note that there's a lack of women in the ICJ and remind those involved of the obligations arising out of the CEDAW Convention. You know that when the judges of the ICJ are elected next year, it will be pretty much at the same time that we are going to have a new Secretary General as well. So there is complementary action. We're involved in that as well, but it's very important that we focus on the role of the Secretary General and others in applying GR40. And number three, we need to work with the Permanent Court of Arbitration members at the national level, the national groups as well, to develop national selection processes if they don't exist. They're not every country has a national process, and really push them to incorporate gender as a consideration when nominating candidates to the ICJ in light of the language of Article 6 of the statute. I know that this sounds a little bit far-fetched, but I want to say that in last year, in the last Congress of the Permanent Court of Arbitration, they adopted a resolution, and among the many things that they say, they urge PCA parties and the Permanent Court of Arbitration to consolidate gender equality and promote the presence of women in technical and decision-making positions within the institution, further increasing the number of female arbitrators, and why not judges of the ICJ, and to raise awareness among the contracted parties to achieve an increased participation of women in other instances such as national law. So the language is there. We have GR40. We have the PCA resolution. Now we need to work. Thank you.
Thank you so much for those remarks. And it is now my pleasure to introduce Professor Margaret de Guzman. Margaret de Guzman is a professor of law and co-director of the Institute for International Law and Public Policy at Temple University's Beasley School of Law. And she also serves as a judge of the International Residual Mechanism for Criminal Tribunals. Professor de Guzman's research focuses on international criminal law, international humanitarian law, human rights, and transitional justice. And she has two very recent publications in the field of feminist justice, which include, first, is International Criminal Law Feminist, and this is published in the Oxford Handbook on Women and International Law with Professor Rachel Lopez, edited by Professor Jarpa Devoni, who's here with us today, and published by Oxford University Press. And then second, Feminist Dreams of Justice, also co-authored with Professor Rachel Lopez, and to be published by the American Journal of International Law, Unbound. So with this, Meg, the floor is yours.
Thank you so much, Milena, and thank you to both you and Jess for organizing this important conversation. I wish we didn't have to keep having it, as others have already said, but I'm glad that we're having it since we have to. I also want to shout out to my fabulous research assistant, Megan Gold, with whom I talked through some of these issues of what I wanted to say and who's here with us today. I also just by way of introduction, I always have to say that I'm speaking in my individual capacity, not as a judge of the International Residual Mechanism. I also wanted to start off by acknowledging the question that we have already raised in the Q&A about if we're talking about equality for women, do we risk reinforcing the gender binary? And I think that's a really important question that the editors of the Oxford Handbook, including Professor Devoni, tackled, I think, very well in that volume. So I would refer people to that as a great resource. I will continue to use the term women, but I want to note that I'm not by that meaning to exclude based on any kind of gender identity. For shorthand purposes, though, I will continue to use the term. So the question that I was asked to talk about is, does a focus on women's human right to equal participation undermine other goals, or how does it interact with other goals like promoting feminist judging and ensuring a focus on intersectionality? In other words, do we need more women or do we need more feminists, including feminists who focus on intersectionality? And it won't surprise you to learn that my short answer is that we need both. But I'm going to say a little bit about why. First, we need to focus on women's right to equal participation because women often, although not always, but often have life experiences that enable us to bring important perspectives to the judicial process that would not otherwise be included. And here I have to shout out to now Judge Hillary Charlesworth's very important, groundbreaking foundational article, along with Christine Chinkin and Shelley Wright in 1991, Feminist Approaches to International Law, where they first drew on Carol Gilligan's also very important work in child development to note that when girls are asked to solve hypotheticals involving a moral dilemma, they tend to invoke ethics of care and to see things in terms of relationships, responsibility, caring, context, communication, and the like. While boys rely more on ethics of right and justice and analyze problems more in terms of right and wrong, fairness, logic, rationality, winners and losers. So there are some important differences in experience and perspective. And in that article, they conclude that international law has very much failed to take account of the perspectives and experiences more commonly associated with women, and that needed to change. And again, we're talking about 1991. So then for about 2 decades after that, other feminist writers have built on their work in various domains and in various ways. And as Professor Stereo mentioned, I recently contributed to the volume on women in international law with a chapter on is international criminal law feminist, where we really pointed out that although women have made very important, extremely important contributions to international criminal law as judges, lawyers, and advocates, and have really transformed the substance of the law in many ways, which now includes a much more significant focus on crimes that disproportionately affect women. At the same time, there are feminist goals that have very much gone unrealized in the field, including countering gender stereotypes and recognizing the full scope of harms that affect women, particularly in wartime, and the like. So we need more women and we need more feminist women. And I'll just speak briefly about my own experiences as a judge now in this regard, which is to say that on my court, there are 7 women out of 25. Now I think we're down to 24 at the moment. And I immediately felt the effects of that in various ways when I joined the bench. One of the ways was just experiences of discrimination, right? As a woman on the bench, one of my first experiences as I was waiting for somebody to help get something set up in my office was for somebody to come in and say, when is the judge arriving? That was my first week on the job. And another experience that I had was in thinking about issues related to care for judges, particularly in the context of cases where we're listening to testimony about genocide and the most horrific things that can happen, and the most terrible harms that people can suffer, and thinking about and talking to other judges about the need to care for judges in this context. I had very different reactions from, and not just in my court, but just living in The Hague and talking to the various judges in the various courts. The male judges tended to say that they were fine and that there was no need for any conversations, let alone any kind of active affirmative efforts to care for and support one another in this kind of work. And women judges just had a very different reaction. So there's a need for more women. Now, there's also a need for more feminism on the bench. And that includes feminist thinking that is focused on intersectionality. So feminism is not any particular sort of value or conclusion or principle or set of principles. It's a method of analysis. It's actually many methods of analysis. There's no particular feminism that can lay claim to the title, but any kind of feminism, frankly, is welcome. More of any of them is welcome at this point on the bench. And I want to just close, I think I maybe have one more minute, by talking about what Hillary Charlesworth, a very important feminist scholar before she became a judge, has brought so far to the bench and why it's important. And I'll just cite a couple of her separate opinions. One in the advisory opinion on climate change, where she calls specific attention to intersectionality. And I quote, she says, many people experience intersecting forms of discrimination. And she later concludes, in light of all these considerations, in my view, states have a particular obligation to protect the human rights of vulnerable groups. This requires close attention to the potentially discriminatory effects of measures taken in respect to the climate. So, or to respond to climate change, sorry, to be more precise about her quote there. The bringing that focus to intersectionality, to vulnerability, is an important aspect of feminist methodology. She also highlights how forced migration and other effects of climate change lead to non-economic losses, including loss of cultural practices, indigenous knowledge, rituals, and customs. And additionally, in her separate opinion on the advisory opinion on policies and practices of Israel in the occupied territories, she again highlights the importance of intersectionality when it comes to Palestinians, noting that the court, in its main opinion, did not make the additional observation that water shortages in some Palestinian communities have a particular effect on Palestinian women and girls because they have additional needs of water for hygiene and privacy, and they bear responsibility for securing water for household use. There are other examples, but I think I've run out of time. Suffice it to say that I think it's really important to have both women and feminists, and many more of them than we currently have.
Thank you so much, Meg. And finally, last but certainly not least, we have with us Valerie Oosterveld. Valerie is a professor at Western Law and Western Research Chair in International Criminal Justice in Canada, and also former special advisor to the ICC prosecutor on crimes against humanity. Her research and writing focus on gender issues within international criminal justice, and she has also published widely in this field, including on the concept of gender in international criminal law and the interpretation of sexual and gender-based crimes by international criminal courts and tribunals. And she also researches outer space law, particularly international environmental space law, state responsibility in space, armed conflict in space, feminist analysis of space law, as well as Canadian space law. So with that, Valerie, you have the closing word for this part, this official part, the presentations, and then we will turn to some of the Q&A that we're already receiving from our audience.
Thank you very much. I'll spend my few minutes commenting on the question of how barriers can be overcome so as to achieve the goal of a gender equal ICJ judiciary. As you've already heard, achieving gender parity on the ICJ is a matter of justice, a matter of fairness, and a matter of legitimacy of that court. So today I'm going to discuss two barriers to the inclusion of more women in the ICJ and what could be done to overcome those barriers. And the two barriers are, first of all, lack of women on the International Law Commission, and secondly, a lack of women on and considered by the national committees that recommend ICJ judicial candidates. So first, let me turn to the International Law Commission, or ILC. The ILC is a body of 34 international law experts established by the United Nations General Assembly in 1947 to advance the progressive development and codification of international law. And the ILC's work includes preparing draft reports and draft treaty texts on key international legal topics. And importantly for our discussion, service on the ILC is viewed by many states as a key step prior to being put forward as a judicial nominee for the International Court of Justice. Now, the ILC has had a shockingly low number of female members since its creation in 1947. Since its inception, the membership has been overwhelmingly male. And prior to the election of the first 2 female members of the ILC in 2001, there had only ever been female candidates nominated in 1966 and 1991, and they were not elected. However, there has been a positive trend where female members were also elected in 2006, in 2011, 2016, and 2021. And an unexpected vacancy was also filled in 2024 with female members, for a grand total of 10 women out of a total of 249 members who have been elected to the ILC. This disparity is not only wrong, it's not just a legitimacy problem, it violates international law on non-discrimination, as you heard from Corinne and from Claudia. So in order for the gap to the ICJ to be remedied, the gap at the ILC must be remedied, as countries still view the ILC as a pathway to the ICJ, as we can see from nominations for the upcoming round of ILC elections. So how do we do this? Well, the ILC statute doesn't mention gender. It says that in the election of members to the ILC, they should possess individually the qualifications required, and that the Commission as a whole represents the main forms of civilization and the principal legal systems of the world. So what we need is action by states. States need to commit to putting forward more female candidates for the ILC in a public way, one that isn't simply performative, perhaps through committing to this goal through a UN General Assembly resolution, or a public sign-on statement communicated to the UN Secretary General. And countries need to implement transparent candidate selection measures through public calls for nominations communicated to the profession and to law schools across the country. Now, the second bottleneck in the selection of ICJ candidates comes through national groups. You've already heard them mentioned today, whether it's the Permanent Court of Arbitration national groups or alternatives within states. This is the route used by countries. It's provided for in the ICJ statute, but the composition of these groups is often overwhelmingly male and non-diverse, and the consultative processes undertaken within these groups tend to be opaque, making it difficult for female candidates to self-nominate or for the profession to even know that a selection process is underway. So what is needed is the same, as I mentioned, for the ILC: public advertisement to the profession and to law schools, outreach to women's law associations and international law groups, like in my country, the Canadian Council on International Law. So I'm going to end by commenting on the importance of processes, whether it's within the ILC or in the ICJ election, of adopting rules and steps to achieve gender parity. In 1998, I had the privilege of serving as the gender expert on the Canadian delegation to the diplomatic negotiations adopting the Rome Statute of the International Criminal Court. And as one of the leading delegations pressing for a gender-sensitive and gender-competent court, I negotiated on behalf of Canada Article 36 of that statute, which is on the qualification of ICC judges. And the article was originally inspired by the ICJ statute, but because the Rome Statute negotiations happened after the 1993 UN World Conference on Human Rights in Vienna and the 1995 UN World Conference on Women in Beijing, at which both women's rights were reaffirmed as human rights and the need for women's participation in international organizations and justice systems was recognized, that prompted a number of states, a majority of which, mine included, felt that it was very important to aim for gender equity and gender parity in the ICC. So the result was Article 36 of the Rome Statute, which looks somewhat like the ICJ statute, but it also says that when selecting judges, ICC states parties shall take into account the need for the representation of the principal legal systems of the world, equitable geographic representation, and a fair representation of female and male judges. Now, at the time, this phrase caused debate. It was discouraging from my point of view that a number of states made the familiar, well-worn, and untrue argument that saying this would mean that the court would be filled with judges, and here they meant female judges, who wouldn't have been otherwise elected to the court, implying that they would be less qualified. Having said that, they still accepted this phrase, which was the important building block for the next set of negotiations to decide the details on the election process of the 18 judges to the court. The same argument came up from a number of states. As we delved into the details of the elections, they said, we don't have enough qualified women, which, as we know, since the court began its work in 2002, turned out to be untrue. The court has had approximately 50% female and 50% male judges at any given moment, with some blips here or there. And the system is working because of the details of the process that was put in place that has led to this gender parity. And why do I raise this? I raise it because reaching gender parity required state intervention and political will and oversight. The ICC election process has oversight. And we know from our previous speakers that there are binding legal obligations on states, coupled with soft law, to aim for gender parity in these public bodies, including courts and tribunals. And the result has been revolutionary for the ICC, and it is possible for the ILC and the ICJ as well. And I'll end here.
Thank you so much, Valerie. So with that, I would like to turn to audience questions. We have already received a number of excellent audience questions. And I would like to actually start with question number 2, because Meg mentioned this in her remarks. And the question is about gender parity on the bench. So let me read the question, and I'll first turn it over to my co-moderator, Dr. Jessica Corsi, because I know that she has a couple of thoughts on this subject, but then I will open it up to all of our panelists. So the question goes as follows. When we talk about gender parity on the bench, how do we avoid reinforcing the gender binary or otherwise ensuring genderqueer individuals are included in our efforts? So Jess, let me go to you first.
Thanks, Melina, and thank you for asking this very important question. I think it's one that we need to keep asking, and I want to keep this brief because I want to get to all the questions and allow our panelists to speak too. So first, let me just say that of course, genderqueer people exist. Of course, people additional to the binary of men and women exist. Intersex people exist. Transgender people exist. And all people have equal dignity and equal rights, which means that through the human rights lens, all people, including those that live outside of the gender binary of men and women, have an equal right to participate in decision-making, which of course applies to the international judiciary. And do we risk reinforcing or excluding? Yes, we do all the time. So this is something that's mentioned. This is one reason why we take a feminist intersectional lens, so that we can expose the biases, whether it's patriarchy, whether it's colonialism, whether it's the North-South divide, whether it's socioeconomic divisions, right? We have to continually keep an eye on ourselves and reflect, are we reinforcing discrimination? As you may know, there's very little law on people that exist outside of the gender binary. You've already heard experts in international law today talk about how controversial it still is to talk about women's inclusion. And I'm sure you won't be surprised that talking about anybody beyond the gender binary is even more controversial. So I'm happy to send you some publications I have. Please email me where I address this topic. And one of the things I say in the publications is we need more data. We know that 52% of the planet is women, for example. So we know that we're underrepresented, but we need more data on genderqueer people and other people that don't fall into the binary. And we need more laws on it. I mean, that's what I think. People who work in international law often think we need more international law. And we certainly need to keep talking about it and paying attention to equal representation for everybody. So thank you again for that question.
Of course. Now let me open it up to all of our panelists. And Meg, let me not to pick on you, but since this is something you mentioned in your remarks, let me maybe go to you first.
Sure. I really appreciate how Jess emphasized that, yes, we do risk that all the time. And that's part of the methodology that I think a lot of feminists adopt is to be alert to that risk, to be honest when we fall short of our own expectations, and to try to do better. And I think that's something that also is important to model, honestly, in judging and in feminist judging, is an awareness of our own, fallibility, our own tendency to not be as inclusive as we should be. So I do think it's important that we keep the broadest possible lens of inclusion in mind. And at the same time, we're seeing trends in the world that are incredibly regressive, right? So there's a tendency to want to just stop our rights from losing ground. And so I think that we have to be careful about that also, because that could have contribute to a problem where we're focusing less on ensuring inclusivity than we are on trying to, hold the tides or keep the finger in the dike or whatever, whatever analogy we prefer there.
Would any of our other panelists like to weigh in on this question? And if not, we have several other excellent ones.
Milena, I would just add one more thing, which is that if national groups are actually representative of their populations, then it's more likely that the resulting nominations will be diverse, will take into account gender, etc. So that's just one level in which we need to think about representation.
Thank you. Let me move on to the next question, and to all our panelists, if there's something that you would like to say on this topic, you can certainly come back to it at any time as well. So we've also received another excellent and fairly technical question, but an important one from Rebecca Shute, and she talks about ICC judicial elections. So let me read the question and open it up to all of you. For ICC judicial elections, the Coalition for the ICC, coordinates a civil society questionnaire for candidates to help illuminate judicial philosophies and perspectives on reform. Could something similar be envisioned for the ICJ, including questions on gender parity and other gender justice concerns? So any thoughts on that?
Yeah.
Claudia? Yes.
Yeah, I can respond a little bit because we have had a very similar experience in the Inter-American system, where we have had a panel of experts that have assessed candidates for the Inter-American Commission and Inter-American Court for many years. I think it's about 10 years. So we have a lot of experience with that. It's done by civil society, very much like the description that we have from the question. And I think it's a great idea. I think it's a wonderful idea. I think that the only issue is that it requires funding. It requires commitment from the candidates, and it has been difficult for us. And now we have a prestige, and so those candidates, who are nominated, they feel that if they don't show up for our panel, then there is something that they are missing. But I think that you need to build that reputation. And so I guess that with the Coalition for the ICC, there was a whole movement at the time that probably made it easier. And I know that now this has been institutionalized within the process of the ICC, which is not the case in the Inter-American system, for example. In sum, I think it's a great idea. I think it's important to start the process, even if we are not necessarily 100% successful. But if we want the candidates to respond, then you have to have some power to make them respond. And so I think that there are some obstacles that we should overcome, but I think it's a great idea.
Any other thoughts on this subject from any other panelists? Okay, I'm going to take silence as general agreement that this would be a good idea. We have another fairly provocative question, but I think this is a great question. So let me read it and see if anybody wants to weigh in on this one. Given the ICJ's global role and the importance of maintaining its credibility, to what extent should considerations of gender parity influence judicial appointments? While Professor Dermeyer's acknowledges the value of positive discrimination achieving equality, Dame Higgins has emphasized the qualifications must remain the paramount criterion and that gender balance should not be a goal in this context. In light of recent concerns about judicial impartiality, is it reasonable to argue that the ICJ should apply stricter merit-based standards than national courts or political institutions? So perhaps a little bit of pushback, but I do think that this is, of course, Corinne, go ahead. I do think this is an important question. Go ahead.
I think it's a very important question, and it's a question that we face every time when we talk about Article 4 and the temporary special measures. And of course, I understand the pushback a little bit, but it is an article that 189, and you were right there, state parties have signed up for. So this is something that at the time of when the convention was drawn up in 1979, that it was seen as important. And of course, maybe you thought in 79, there's so much difference, there's so much inequality now that it is needed. And you might think that now in 2025, this has been repaired, but it hasn't. And the ICJ is a good example of that. And of course, I've met Dame Higgins several times when she lived in The Hague, and I've met more very prominent first women on our Supreme Court in the Netherlands, and there is also sometimes something in those women themselves that have this feeling, I got here by my worth, and that can sometimes also result in a sort of backlash. And I hope I'm not being in any way disrespectful of Dame Higgins, because I do not mean to be, but I have experienced this also, and I can also understand it. And I can, I have, when in the Netherlands, the first juvenile judge was appointed, female juvenile judge, somewhere in the 40s, the members of parliament, it was talked about in parliament that now that we have appointed a woman to be a juvenile judge, we can also drop the norm that they should be a lawyer, which is really so insulting. But this was the way that it was thought about then. And so I think that it is important to take that into account also. Article 4 is not for nothing. We need Article 4.
Thank you.
Thank you.
Claudia, I see that you've
Yeah, I wanted to give, since we were talking about data, I think it's important because, you know, at GPAL, we get all the time these kind of questions, and we have never argued that women should not have the same merits. But, you know, we monitor 614 positions. So if we are thinking about 300 women among so many in this world who have the qualifications to be, you know, a member of any of these international, I think that we pretty much respond to the question. There are perfectly 300 women who could do it. The question is going back to how we select, you know, the candidates. And I want to say that many times we do have unqualified men who are always, you know, who are also selected. I think that we all know them. I think if you go through the composition of the different international courts or the different international monitoring bodies, I mean, you know, we can see from their resumes that some have less experience than others. So I think that in terms of the merits, no discussion. We would never have claimed that women should not be qualified. But, you know, since we are talking about a very small group of women, I think it's undeniable that we have more than 307 women who could do the job very, very well.
Thank you so much. Jarpa, yes, please, go ahead.
Yeah, if I may come in, and thank you, Marina, for that question. It's a very provocative one, and I'm taking it as being coming from you from a place of informed, you know, analysis, and also maybe reflecting what's been said. I'll say this very quickly. I like to do empirical stuff. And before I get to the empirical, I remember some time ago, I was reading about this topic, and there was a news item, so it can be found just to remember the name, of a judge in the UK, male judge, who had made a statement that having more women in the judiciary was going to water down the judiciary. Now, what does this mean? That there is a strong element of socialization which we have to work with. There's a need to deconstruct people's minds about this 1900 perception that women should be at home and men should be in the public sphere. And this still affects women. So if people in such high positions as a judge can make this statement, of course, that means that we do have a lot of deconstruction to happen. Now, you might think, well, deconstruction is about evidence. We have said that at least there is enough evidence and data to show we have qualified women. Even though women in some countries were not allowed to acquire a legal education until much later, universities in the US and other places didn't allow women to go to law school until much later. Women have been able to leapfrog and to get a necessary experience. So how do we address such questions? It's all about perspective, it's all about socialization, and it's all about the need to deconstruct such very old ideas about women. Now, let me give you a quick example. I'm wearing my vision glasses here. I see you all differently. I will see the world differently, and I'll see gender issues and whatever it is I'm looking at. Now, if I took this off and I put on my reading glasses here, which would be down here, I would see different things from different perspectives. So if I'm looking above that, I'll see differently. If I'm looking down when I'm reading, it will give me a different result. Now, this is the other glass, which is my progressive. I look up here, I can still see well, and I look down here and I can still read. Just 3 of the examples, not to say that I have too many glasses. Well, I get renewed every year with my insurance, but I always use this with my students. The lens through which we look at the world, we look at the courts, ICJ, you name it, will influence our perspective about who has the right to be there, who shouldn't be there, and why we think that if you fit into this model, then you're good. And therefore, if somebody puts on the 1800 lens, they'll say, well, women shouldn't even be here. I don't see it. So this is a need for us to look at this issue as a need for deconstruction of gender norms. But let me end on this note. That just last week, I taught my students on the crisis of masculinities. It's a real issue we need to think about. The backlash we're seeing now, more than ever before, is also an issue of masculinity. So when we're discussing these issues about representation, we need to talk about the crisis of masculinity that is also leading to these 1800 assumptions being reinvented and reapplied. If women can take care of human beings in our bodies for 9 months and not harm them, I'm sure we can find those women who can sit on the courts of the International Court of Justice and make very important cases that would affect the very humanity that we brought into the world. That's just my empirical, biological argument. I hope it works.
Thank you so much. And I know that my co-moderator, Dr. Jessica Horsey, has a quick word on this as well. Go ahead.
Thank you. The question itself assumes that merit and gender equality are incompatible, that they're mutually exclusive. And in fact, the reason that it's Article 4 of CEDAW and of other conventions like CERD and in other national laws is because they're not mutually exclusive. Merit and equality are mutually reinforcing. So we know that there are more than enough qualified women to sit on the bench of the International Court of Justice and other judiciaries and other decision-making bodies. And we also know, and speaking of data, we have ample data that bias keeps them out, and that merit is interpreted in job interviews or in nominations or selections through the lens of bias. And that's actually why we need these rules, so that we can get qualified people of all genders into decision-making roles.
Thank you so much. Well, I hate to cut off this amazing discussion, but we are out of time. So thank you again to our host, Abila, for hosting, sponsoring this webinar, but also to all of our co-sponsors, the Working Group for Gender Parity for the International Court of Justice, and also the Institute for African Women in the Law, Women in International Law Interest Group at the American Society of International Law, GQUAL as well, and the Institute for African Women in the Law. We look forward to seeing many of you at the ABILA International Law Weekend Conference next week in New York at Fordham Law School. And we also invite all of you to join us for our next event, which will take place on October 31st in New York City at the offices of Simpson, Thatcher, and Bartlett. This will be a UN 6 committee side event this will be an additional discussion on gender parity for the ICJ bench with our government, the United Nations, as well as civil society colleagues. If you're interested in attending that event, which will take place again in person on October 31st at Simpson Thatcher, please contact my co-moderator and colleague, Dr. Jessica Corsi, via email to register for this event. Because it's taking place at the offices of a law firm, you must register in order to have access to attend in person. Thank you again to all of our panelists for your amazing contributions today. I look forward to future conversations, and thank you again to all of our audience members for joining us today. The webinar has been recorded and will be available for later viewing by anybody. So thank you so much and have a great weekend.
Thank you.